In the aftermath of the recent documentary broadcast on Channel 4, Dr. Dewi Evans wrote a letter which has apparently been distributed to numerous newspapers. There are several problems with this letter, but in this video I'm going to examine one particularly extraordinary claim, and I'm going to show you why Dr. Evans is definitely, undeniably lying. The paragraph that I'm referring to is on the screen now, and I will read this out loud. Given the time constraints, it was inevitable that the documentary concentrated on just a couple of cases. The timing of Baby C's collapse created confusion. In my very first report, I raised concerns regarding the event late on Saturday the 13th of June 2015 that led to his collapse and death. Over the next 5 years, the dates seemed to have become confused, leading to the prosecution alleging that the assault took place the previous day. I recognised the confusion at the trial, reaffirming my original concern that the fatal assault was late on the 13th of June. I believe that Cheshire Police, the Crown Prosecution Service, and the prosecution team should set the record straight. Now, it was already considered fairly remarkable that Dr. Evans is requesting for Cheshire Police, the Crown Prosecution Service, and the prosecution team to set the record straight. But in this video, we're going to examine the claims that he's made in this paragraph. Essentially, there are two claims. The first one is that Dr. Evans changed the date because the prosecution, CPS and/or police made mistakes in court that he recognised. The second claim is that he had included the 13th of June incident in his initial report. However, inspection of the court proceedings from Tuesday the 1st of November 2022, when Dr. Evans entered the witness box to discuss Child C, paints quite a different picture. I'm firstly going to examine 6 specific exchanges that occurred in court. During cross-examination, Defence Barrister Ben Myers KC establishes that Dr. Evans has changed his view since the court case began, and then asks him plainly about his shift in opinion. So I'll read this out loud. Myers, before today, just now, you've never suggested that splinting of the diaphragm on the 13th of June is the cause of death, have you? Evans, that's correct. Myers, this is the first time we're hearing it right now, isn't it? Evans, yes. Later in the cross-examination, this point is then reiterated by Myers again. And again, just to make it quite clear, in not one of the reports before today have you suggested that splinting of the diaphragm on the 13th of June was a cause of death. Evans, that is correct. As the cross-examination continues, Myers gives Evans numerous opportunities to explain that the police, Crown Prosecution Service and prosecution have mixed up the two dates, and also that Evans has included this new claim in previous reports. Myers, you have not, in these reports, up until your evidence now, identified any specific way in which he was put in harm's way on the 13th of June, have you? Evans, not in this first report, no. Myers, there are several reports, aren't there? Evans, yes. Myers, in none of which do you mention splinting of the diaphragm on the 13th, do you? Evans, no. You have mentioned that, and I have said, no, there isn't. This is again reiterated in a further exchange between Myers and Evans. Myers, in that report, a matter of months or a month or two before this trial commenced, you make no suggestion that the diaphragm had been splintered by excessive air on the 13th of June, do you? Evans, right, that follows actually, perhaps it wasn't said specifically. Myers, can we establish that first of all? Evans, yes, that is correct. Myers, you didn't. Evans, yes, that is correct. And Myers provides one final opportunity for Evans in this section of cross-examination. Myers, no, in that report, your view, Dr. Evans, I'm sorry if the question wasn't clear, at that time you had nothing to say in August of this year as to splinting of the diaphragm on the 13th, had you? Evans, no. So let's go back and look at what is claimed in the letter. The two key claims are that Evans changed the date because the prosecution, Crown Prosecution Service and/or police made mistakes in court that he recognised, and he had included the 13th of June incident in his initial report. So we can now look back at these 6 opportunities that Dr. Evans had to make either of these two claims that have just been written in this letter. So I'll read through those again. Myers, Before today, just now, you've never suggested that splinting of the diaphragm on the 13th of June is the cause of death, have you? Evans: that's correct. Myers: this is the first time we're hearing it right now, isn't it? Evans: yes. Myers: and again, just to make it quite clear, in not one of the reports before today have you suggested that splinting of the diaphragm on the 13th of June was a cause of death. Evans: that is correct. Myers: you have not in these reports, up until your evidence now, identified any specific way in which he was put in harm's way on the 13th of June, have you? Evans: not in this first report, no. Myers: there are several reports, aren't there? Evans: yes. Myers: in none of which do you mention splinting of the diaphragm on the 13th, do you? Evans: no, you have mentioned that, and I have said, no, there isn't. Myers: in that report, a matter of months, or a month or two before this trial commenced, you make no suggestion that the diaphragm had been splintered by excessive air on the 13th of June, do you? Evans: right, that follows actually, perhaps it wasn't said specifically. Myers: can we establish that first of all? Evans: yes, that is correct. Myers: you didn't. Evans: that is correct. Myers: no, in that report, your view, Dr. Evans, I'm sorry if the question wasn't clear, at that time you had nothing to say in August of this year as to splinting of the diaphragm on the 13th, had you? Evans: no. So Dr. Evans claims that this collapse was in his initial report. So we see Myers ask him here, you have not, in these reports, up until your evidence now, identified any specific way in which he was put in harm's way on the 13th of June, have you? And Dr. Evans says, not in this first report, no. So he can't even make the claim that he didn't specifically mention splinting of the diaphragm. He mentioned the collapse and some sort of non-specific incident related to that. He can't even make that claim. In all that, he's given numerous opportunities to do so in the court case. However, the first claim that Dr. Evans recognised that the dates had been mixed up and that he corrected this in court, clearly you would express that explicitly. There would be very significant and important meetings with the prosecution. It would be a major embarrassment for the prosecution that they'd mixed the dates up. And they would have to concede this, particularly during the court case. There's no indication of this whatsoever. As I say, there's these 6 opportunities that Dr. Evans has to say, well, actually, I've just noticed that we've cited the 12th of June, but in fact, I've realised the prosecution, the CPS and the police got it wrong. You know, it's the kind of thing you would tend to bring up in court if indeed that had occurred. And when I saw this claim in this letter, I immediately recognised that I'd never heard this claim before. I mean, it's the kind of thing that you would tend to remember if someone had said it previously. And then it just dawned on me, well, he actually discussed this in court. So at this point, I went back to double check the transcripts, and sure enough, he was asked about it multiple times. Not on one occasion did he ever say, well, actually, I noticed that the prosecution has made a cock-up, which you would tend to say when cross-examined. He said, as you can see quite explicitly, I've changed the date because I've changed my opinion. So the claim that he's made in the letter is palpably untrue. In the aftermath, contrary to what is claimed in this new letter, at no stage during the court proceedings does Dr. Evans make any reference whatsoever to anyone involved with the preparation or presentation of the case having mixed up the dates, nor does he indicate that he had cited the 13th of June incident in a previous report. In fact, Evans quite clearly states the complete opposite. I want to remind people that when he was speaking in the Channel 4 documentary, Lucy's barrister Mark MacDonald noted that there is a new report from an expert who's changed his mind on a murder case. I have never known anything like this to happen. They thought she was there. They made a mistake. She wasn't there. So I'm now going to go through the whole of the cross-examination of Dr. Evans on Tuesday the 1st of November 2022 so that you can see I'm not being selective. I'm not going to do too much analysis of what is said because I'm just going through this exercise so you can see I'm not just selecting certain extracts from this cross-examination, but actually he said something of relevance at another point. I want it to be demonstrated undeniably that what he is saying in this letter is untrue. In the aftermath of the cross-examination of Dr. Evans on Tuesday the 1st of November begins here. It begins with Myers saying, Dr. Evans, you've explained today that your conclusion is that the cause of death in baby C's case arose from the splinting of his diaphragm. That is, the mechanics of that, yes, is correct. You've had the relevant clinical material and the statements relating to baby C for over 5 years, or thereabouts 4.5 years, haven't you? Yes. You've considered other cases featuring in this trial where you have provided reports giving the opinion that splinting of the diaphragm is a cause of death, like baby G, haven't you? Yes. Before today, just now, you've never suggested that splinting the diaphragm on the 13th of June is the cause of death for baby C, have you? That's correct, Dr. Evans says. This is the first time we're hearing it right now, isn't it? Yes. You are alert to the possibility of splinting of a diaphragm from the other cases you've looked at, aren't you? Yes. Your opinion, I'm going to suggest, and as far as you can go on the material available to you alone, would not take us to splinting of the diaphragm on 13th of June, would it? So then Evans begins his usual waffle. Well, I don't jump to conclusions. So therefore, as we discussed earlier, this death was unexpected and could not be explained as a result of one or more of the usual illnesses that premature babies get. Doctors work as a team. We rely on opinion from other sources. And if you look at the combination of what I thought his clinical situation was, plus what I've read from Dr. Manarides' report and others, and on top of that, the gaseous distension in the stomach, putting it all together, that is an acceptable cause of collapse, in my opinion. So before we go any further, I just want to remind people, he's supposed to be saying that the police, the Crown Prosecution Service and the prosecution got the date wrong. Let's not forget that. I'll remind you of that every few minutes. If you really thought that splinting of the diaphragm in the case of baby C was a cause of collapse, you would have said that before today, Dr. Evans. Not necessarily. I think when I came to this court, first of all, I said that having prepared these reports initially over 5 years ago, in virtually all of the cases I benefited from additional information since then, from other experienced medical people. And if you receive additional information from other people in other disciplines, which allows you as a clinician to change or modify your opinion, that is what doctors do. I was functioning very much as a clinician in any case of this nature. So then Myers says to him, I suggest, Dr. Evans, you have been driven by something which leads you to support the allegation rather than something based on the facts beneath it. That's what's going on here, isn't it? No, the fact is this baby collapsed having been stable up until more or less the minute of his collapse, and therefore one has to explain that. I just want to deal with what you have said in, is it 8 reports that you prepared in the case of baby C plus 1 joint report? That's correct, isn't it? I think so, yes. Yes. And again, just to make it quite clear, in not one of them before today have you suggested that splinting the diaphragm on the 13th of June was a cause of death. That is correct. The first report that we heard about, which is on the 7th of November 2017, in that report, Dr. Evans, you said that your paragraph 33, one may never know the cause of baby C's collapse. He was at great risk of unexpected collapse. That's paragraph 33 of that first report. All of this is correct. So you agree he, in fact, was at great risk of unexpected collapse. He was at risk of one or more of the complications you get in preterm babies we discussed earlier. Your words are, and then Dr. Evans interrupts Myers, sorry, this is going to be a load of waffle again. But although he was at risk of them, he was in a neonatal unit, designated to look after him with continuous monitoring of essential criteria such as oxygen, etc. So therefore, the risk was there. This is why neonatal units exist. They are to look after babies at risk of death, collapse or serious injury. Therefore, the risk was there, and if he had not collapsed on the 13th, he could well have, the risks were there until he was much bigger. So this is just the usual crap he comes out with. But let me remind you, he's supposed to be telling the court that he's noticed that the police and Crown Prosecution have got the date wrong. So the risk is there. The risk is there constantly. But although the risk was there, I was satisfied. What on earth is going on here? I think we heard Dr. Gibbs say he couldn't explain why this baby collapsed either. That's a pretty straightforward statement, actually. One may never identify the cause of baby C's collapse. And then Evans starts to say, "Are you saying?" And then Evans interrupts him. "I'm not the only doctor giving evidence on this particular baby, and therefore they will give evidence in due course, so that's as far as I could get based on the information I had in 2017. And then Maya says to him, "Let's be clear. What you say there, based upon the records that you had access to and those statements at that point, was one may never identify the cause of his collapse." Yes. You were ready to acknowledge that then? Yes. And you were ready to acknowledge he was at great risk of unexpected collapse. Do you agree? Yes, yes, yes. Let me just remind you at this point, he's supposed to be citing the fact that in the first report, he'd already written the date as the 13th of June. So he'd already said this baby collapsed on the 13th of June. I just want to remind you of that as well. You also form the view that you cannot exclude the role of infection in his collapse, paragraph 34. Yes, I'm quite happy to elaborate on that. Let me just ask before you do. That's on the basis of the sort of material in the medical notes that we've been looking at now, isn't it? Yes. And faced with that, back in 2017, you were able to say that we cannot exclude the role of infection, weren't you? More waffle now, from Dr. Evans. Infection was a factor in baby C's short life. We know that. We know he had pneumonia, so it was a factor. It is possible to suggest that if he did not have pneumonia, he may not have suffered the collapse. No, I want to rephrase that. So he realises there that he said pneumonia could have caused the collapse. So he's now going to say something completely different. His pneumonia was under control. That's the important thing. He was on antibiotics. He was requiring hardly any additional oxygen, and his saturations were spot on. So therefore, his pneumonia was under control. But it's my role. I was investigating this unexpected collapse. It was my role not to give an impartial view looking at all these issues. In other words, I don't prepare partisan reports, so therefore if you've got a CRP of 22, I've got to bear it in mind. If you've got an X-ray that shows pneumonia, I have to bear it in mind. Are a CRP of 22 and a pneumonia on X-ray in a baby requiring 25% oxygen sufficient explanation to cause his collapse? In my opinion, no. Your opinion, sorry Dr. Evans, please continue if there's more. No, I finished. Your opinion, do you agree, in that report, was that you cannot exclude the role of infection. Infection was a part of baby C's general status during his life. You didn't say in that report infection was part of his general status. Dealing with your opinion as to death, you said you cannot exclude the role of infection in his collapse. It's there, Dr. Evans. And then Dr. Evans says, infection was a factor in his life. Did it contribute? It didn't cause his death. That's what I believe didn't kill him. Saying you cannot exclude the role of infection in his collapse acknowledges that it may have played a part, doesn't it? It may have. It was a contributory factor. We heard about the four main contributory factors earlier today. Well, now you've come to give evidence to the jury on the same occasion that you introduced splinting of the diaphragm, you have today discounted infection in any way, haven't you? No, I have not discounted infection. I've explained to everybody that the report of Dr. Manarides, who's the pathologist, highlights the issue of abdominal distension causing the diaphragm, causing splinting of the diaphragm. Now, can I just ask something about that? Please do. You are not just here to repeat what's in the report of Dr. Manarides, are you? Here's more waffle coming. I am here, right. What we do as clinicians is this. We base our opinion on an accumulation of information. Okay. Nothing to do with being in a court or anything. We rely on 3 items of information: the history, the examination, and the investigations. So we put all of that together. In a patient who sadly dies, we then turn to pathologists to see if they can enlighten us on information that we are not too certain about. There's no point in getting a pathology opinion. If I knew everything, I would not need a pathology opinion. So therefore, you need all of those things. The greater the bits of information you have, then the more likely you are in reaching a diagnosis. So in this particular baby, I'm not going to repeat what I said earlier. We know the history. He was a preterm baby. We know what the examination findings showed. We know what the investigation showed. The markers of infection are pretty marginal. A CRP of 22 in an otherwise a baby who wasn't just had an infection. It's important, Mr. Myers, to know he was recovering from an infection. If I didn't say that too clearly in my report, well, there we are. But his supportive therapy wasn't getting worse. It was getting less, because for the last 12 hours of his life, he was off his CPAP, right? He was off his CPAP. All he had was Optiflow, which is basically nasal prongs to deliver, so you know exactly what percentage of oxygen the baby's getting. So therefore, respiratory-wise, he wasn't even staying the same. He was improving. Now, I could analyse a lot of this. I'm not going to, because we're just going through this Because remember, he's supposed to be saying the prosecution used the wrong date, and he's also supposed to be saying, I said all this in my original report. Can I ask you this, Dr. Evans? Are you trying to use what you anticipate will be the evidence of Dr. Manriquez, the pathologist, to find a way of producing an allegation as to the harm that was done on the 13th? No, which you haven't made before today. Sorry, this baby was put in harm's way. That's something, so far as the 13th is concerned, that until you give your evidence now, you've not identified to this point on the 13th, have you? What I did initially was, can I ask that first, please? Can you answer that question? Ask it again. You have not in these reports, up until your evidence now, identified any specific way in which he was put in harm's way on the 13th of June, have you? Not in this first report, no. And you are coming up with things here now as we go along to try to support an allegation of harm on the 13th of June, aren't you? No, I'm coming up with clinically proven mechanisms that explain why babies collapse. Well, let's move then to your next report, the second one. One specific reference was made to it on this is of the 31st of May 2018, 6 months after the first one. Yes. In that report, you say at paragraph 36, having had time to reflect from my first report, one may never identify the cause of baby C's collapse. That is correct. He was at great risk of unexpected collapse. Yes. That was your considered opinion, wasn't it? Yes, it was. And that's the position, isn't it? One may never identify the cause of baby C's collapse, and he's at great risk of unexpected collapse. Right. He was at great risk, okay? This is Dr. Evans waffling again, in case you can't tell. He was at great risk. That's quite a big difference between being at risk of unexpected collapse and actually finding a cause for it. Again, as I have said, as a clinician, you play as a team, and part of your team in a child who sadly dies is the pathology. Is your team the other prosecution experts, Dr. Evans? No. Who's your team, so we can be clear? The medical team. I have not seen any report that comes up with an explanation regarding baby C's collapse other than what I have said today and what Dr. Manriquez has said in his report and what other people will say. I have read reports that are, I don't mean this disrespectfully, I've read reports that come up with this idea and that idea and the other idea and all that other sort of stuff, which is very interesting to me because I'm a clinician. I want to know what could have caused all this, but I have not seen a single report. I am happy to be corrected on this one. I've not seen a single medical report that says, I am wrong, baby C died because of something else. Well, you have now. I have not seen a single report that gets off the fence and tells me that. I am happy to be corrected, Mr. Myers, but I have not. Are you happy to be corrected, Dr. Evans? Are you happy to be corrected? Because that doesn't strike me as your current position. So then Dr. Evans continues, therefore, this would always be this case, right? This case would always be a challenging case for any clinician, and it's a challenging case because we know of his various pathological problems, so it is quite difficult to separate the pathological problems, infection, feeding, etc., that we heard about earlier. It's quite difficult to separate those from an event where he was placed in harm's way as a result of some kind of deliberate act. Now, I don't think I could do that alone, but putting all the evidence together, then that is where we are. So I just want to remind people at this point, Dr. Evans is supposed to be telling the court that the prosecution has identified the wrong date and that this collapse that he cited on the 13th of June was in his original report. In the aftermath of... So Ben Myers continues, I'm looking at what you say here, Dr. Evans. You don't mention in this report, the second one we came to, anything about splinting the diaphragm on the 13th, do you? No, you've said that several times and we have all heard it. There are several reports, aren't there? Yes. In none of which do you mention splinting the diaphragm on the 13th, do you? No, you have mentioned that and I have said, no, there isn't. You also, in this report, paragraph 37, repeat that you cannot exclude the role of infection in his collapse, don't you? Paragraph 37. It is a factor in his general status, yes. And that's the truth of the matter, isn't it? You cannot exclude infection from his collapse. What you cannot do, you cannot exclude infection as a factor in his general status. What I can do, looking at all of this, remember I prepared a load of reports looking at all of this, is this. He's got an infection, but it's under control. And we all, I've listened to the evidence from the other people. We've all heard the evidence from the local teams. It's your evidence we're looking at now, Dr. Evans. Yes, I'm aware of that, and that's my evidence. Let's move forward to about a year or so later, 26th of March 2019, the next report, paragraph 13. I don't have paragraphs on my copy, hang on. It's page 6 of 7. I beg your pardon, I do. Two things here, page 6 of 7. Having reviewed all of this about a year later, you say, and it's in the centre of that paragraph, it's therefore probable that infection was a significant factor in baby C's collapse during the late hours of the 13th of June 2015. Yes, I've seen that, yes. So I just want to go back a second and we'll go over this again. I do just want to point something out. So every time, if you notice, this has already happened twice, I believe, already. He says, I don't have a copy of that. And then Ben Myers points out where it is and he goes, oh yeah, actually I do. I posed a rhetorical question. Could this gentleman even deal with the amount of documents that he had to deal with? We saw how many pages he had because he advertised that during the Channel 4 documentary. It's thousands and thousands of pages. He barely seems to know what time of day it is. Every time he's saying, I haven't got that document, well, it's actually there. Oh, yeah, so I have. Is he actually competent enough to even look after documents, I ask you? So I'll just read this again, because I just wanted to reflect on that. Let's move forward to about a year or so later, 26th of March 2019, the next report. I don't have paragraphs on my copy, and so it goes on. It's therefore probable that infection was a significant factor in baby C's collapse during the late hours of the 13th of June 2015. Yes, I've seen that, yes. And you recognised then that infection may be a significant factor in his collapse, didn't you? So it's important to note, it's now 2019, this is his third report. He is very clearly stating that on the 13th of June 2015 that infection is a significant factor. He's not talking about the 12th of June. This is the 13th of June that he ultimately cites in the court case. And he has said that the police and the Crown Prosecution Service and the prosecution itself got the dates mixed up. And that he'd always cited the 13th of June as being significant. But we can see here very clearly, very explicitly, he's kind of ruling out this collapse on the 13th due to infection. And he's certainly not citing it as important. And you recognised then that infection may be a significant factor in his collapse, didn't you? That was my opinion at the time, and as I have said, if as a clinician I receive additional information that allows me to change my opinion or modify my opinion, that is what we do as clinicians. But nothing has changed with regard to evidence of infection, Dr. Evans, since then. You may have heard other things from Dr. Manarides, but nothing's changed on the evidence of infection, has it? No, he had an infection, he had pneumonia, it was on the monitoring that was present on the little baby, his monitoring was fine. The same evidence of infection is before the jury now as was before the jury at the time you came to that conclusion, isn't it? If this, we are not relying, well, we're not relying on my evidence alone. With this particular baby, I couldn't take it any further than what we've discussed this morning and confirmed just now. I'd love to analyse all of this, by the way, but it would take about 3 hours. But you see, in March 2019, the possibility of someone forcing air down the nasogastric tube was in your mind, wasn't it? It was actually, but not on the 13th of June, yes. I don't know what you mean. Let me help. If we go to paragraph 14, please, Dr. Evans, the jury, oh yes. The jury will recall we've seen the abdominal x-ray for the 12th of June at 12:38. Yes, right, yes. And as to that, what do you say? We've had a paragraph where you say, it's therefore probable the infection was a significant factor in baby C's collapse during the late hours on the 13th of June. In the next paragraph, you go on to say this. I am suspicious of the gaseous distension reported on the abdominal x-ray on the 12th of June and wonder whether this represents inappropriate management whereby his attendant inserted excess air into his stomach via his nasogastric tube, doing so in the knowledge that would cause the infant discomfort and distress. That was a possibility that crossed my mind at the time. At the time? Just at the time? No, when I read this statement. So remember, Dr. Evans is supposed to be saying, in court, he's supposed to be saying at this point, oh, the prosecution just got the dates mixed up, so I'm here to tell you that it's actually the 13th that's important, not the 12th. I'm sure he'll start saying that soon, though. When you say at the time, is it a possibility that came in and went out with this report, or did it stay with you for longer? I don't know what you mean by that, actually. Is it a possibility that existed only when you did this report, or have you stuck with the theory that there was air force down the nasogastric tube on the 12th of June? Then Dr. Evans starts to say, right, whether. Can you answer that question first? Help the jury with an answer, please, Doctor. With regard to the 12th, that was one option. The other option was the CPAP. Because he was on CPAP at the time, which he wasn't when he collapsed, but he was on CPAP at the time. So that was one option. The other option was inadvertent air, and we can't discuss it now. We'll discuss it later in the trial in relation to other cases. Therefore, by this time, I was aware of the fact that several babies had collapsed, some had died in Chester, and yes, so all of this was adding to my anxieties about what was causing all of this, yes. And your view back in March the 19th was that there could have been deliberate harm done on the 12th of June via the nasogastric tube, yes. Can't rule it out. Pardon. There were two scenarios. Mr. Justice Goss, can't rule it out, he said. I apologise, my lord. You can't rule it out, two scenarios. That's one of them. The second one is he had CPAP. He was on CPAP at the time. If we come forwards, there was, we know, a report prepared after a joint meeting of experts in August of this year, wasn't there? Yes. And Dr. Marnaridis was present, at least for part of that meeting, wasn't he? Yes. The date of the report, there are various dates on it with the signatures, but we are looking at a period at or about the end of August. You signed it, Dr. Evans, on the 24th of August 2022. Yes. Page M1257, my lord. Thank you. That's where it starts. At page M1260, page 4 of the report, you were dealing with opinions on baby C. This is a report that you signed off on, really, a month or two before this trial commenced, wasn't it? Yes. In that report you say, the massive gastric dilation seen on the X-ray of the 12th of June was most likely due to deliberate exogenous administration of air via the nasogastric tube. That's what you say, isn't it? That was our conclusion at the time. Bear in mind, this is at the pre-trial meeting. So Dr. Evans has claimed, I made it very clear in my first report from 2017, and I noticed during the trial they got the dates wrong. So they're having the pre-trial report, they're still looking at his thing on the 12th of June, where he's saying the massive gastric dilation seen on the X-ray was likely due to the deliberate exogenous administration of air. Then, as we know, as has been pointed out, it becomes evident that Lucy Letby was on duty. Then he changes opinion in court. He claims in this new letter that he noticed that the prosecution had got the dates mixed up and that the police should clear this up. But he never said this in court. We can see this with crystal clear clarity. There is absolutely no doubt that he's either lied in court or he's lied in that letter. Those are the only two possibilities. There are no other possibilities. But we'll continue with the court transcript. Yes, but that's a conclusion between you and Dr. Bohin, isn't it? Yes. By the time you did that, you had all the material you required on the care of baby C, didn't you? Yes, I think so. Yes, and armed with that material, your view was that the 12th of June was probably due to deliberate exogenous administration of air. Is that correct? That was a possibility, yes. Most likely due to that, you say. In that report, a matter of months, or a month or two before this trial commenced, you make no suggestion that the diaphragm had been splintered by excessive air on the 13th of June, do you? Right. That follows actually, perhaps it wasn't said specifically. Can we establish that first of all? Yes, that is correct. You didn't. Yes, that is correct. So Myers continues. There are about 13 different points under baby C. Sorry, I haven't got a copy. Let me ask this. If you had wanted to say it was splintering of the diaphragm, nothing stopped you from saying that, did it? If it wasn't said, it wasn't said. No, it wasn't said because it wasn't something that you had entertained as a possibility at that point, was it? Right. That is incorrect. What we've discussed here is, let's stick with the 12th, okay? There was a distinct possibility that baby C had excess air injected into his stomach on the 12th. That's what we said. At the same time, we realised that however much air was in his stomach, he was still stable from a respiratory point of view. So therefore, excess air injected into the stomach, it's a complicated description this, injected start again. This is all Dr. Evans waffling, in case you can't tell. Air injected into the stomach will cause the stomach dilation, but it will compromise the baby only if there's sufficient air and there's sufficient pressure to splint the diaphragm right. Now, on the 12th, baby C was in CPAP, which is a pretty non-invasive method of respiratory support. So therefore, however the air went in, it would have been sufficient to splint the diaphragm on the 12th, okay? Because if it had splinted the diaphragm on the 12th, he'd have died or collapsed on the 12th. He didn't. So therefore, however much air went into his stomach and intestines on the 12th of June, so we're talking 36 hours prior to his collapse, that and I have no idea how much air went in. However much in was insufficient to destabilise baby C from a respiratory point of view. So therefore there was nothing to suggest that the extra air would have splintered the diaphragm at that time, okay? That was the last x-ray, by the way, that was taken. That's not a criticism, by the way. The one on the 12th, that was the last x-ray. So the only x-ray evidence we have is from the 12th. We don't have any from the 13th. Therefore, I hope that distinguishes what I think is a scenario that occurred on the 12th compared to the scenario that occurred that led to his collapse. Dr. Evans, we're looking. The two are different, both in relation to volume of air that got into his stomach and intestines and the other. In other words, it did not compromise him. And the second thing which we're aware of is that he had CPAP, he was on CPAP as well. So the two events are quite different in the way that they affected baby C. Looking at your opinions, before we get to what lies behind this, your opinions and the way you have formed them, and I'd just like to be absolutely clear that as of a month or two before this trial, whatever may or may not happen as a result of it, your view that 12th of June was intentional harm, wasn't it? That was a possibility, yes, it was. Yes, that was your view. At the same time, you had nothing to say about splinting the diaphragm on the 13th, did you? On the 13th, I think he collapsed, no. In that report, your view, Dr. Evans, I'm sorry if the question wasn't clear, at that time you had nothing to say in August of this year as to splinting the diaphragm on the 13th, had you? No. Remember, let me remind you again, Dr. Evans is supposed to be saying here two things. He's supposed to be saying the prosecution got the dates wrong, and I'd always said that the 13th was significant, and Dr. Evans is also supposed to be saying this was in my initial report. So then Ben Myers continues. No, what you have done in your evidence today is introduce something new with the purpose of supporting the allegation rather than explaining the facts, isn't it? No, that is incorrect. I'm here to support the jury and everyone in this court trying to explain what was it that led to a baby who was very small and premature suddenly collapsing and where resuscitation was unsuccessful. In doing that, I am totally upfront in saying that I am not relying on my opinion alone. I'm relying on other medical people's opinion as well. That is what doctors do. We do it all of the time. That is what we do. Okay. So I'm here to assist the members of the jury in sorting out what is a pretty complicated case. So I will just reflect on something here for a second. So he says that what doctors do is reflect on other medical people's opinion. So when Dr. Evans hears the international panel of 14 experts at the time, now 26 experts, and they say, look, there's all these medical conditions and things that you haven't taken into consideration, would you say he was receptive to that? I would say that he wasn't particularly receptive to it, although he claims here that he likes to listen to other doctors. Let's continue. So Ben Meyer says, I'm suggesting to you, Dr. Evans, that you are reaching for things that support the allegation rather than reflecting the facts. Well, I disagree with you. I have just explained the facts, right, to you, and that's it. Before I proceed with this, I'd like to ask you about one thing that occurred when you gave evidence with that point in mind. It's something I couldn't deal with at the time because of the way that the evidence ran. I wonder if we could just put up, and I'm sorry we have to go to Baby B documents just for the purpose of this. Could you please put up, Mr. Murphy, slide 233 from the Baby B pictures? I'm raising this question about your approach to the evidence, Dr. Evans. Page 1282 under Baby B. You need to come out and go back in again, and then it is slide 233. Just to reassure you and everyone else, Dr. Evans, and the jury in particular, we'll get back to Baby C shortly. Could we go behind that slide, please? When you last gave evidence, we spent a little time looking at the colours relating to Baby B and what you wanted to say about that. If we go over the page to the point where Dr. B, whose notes there are, I apologise, Mr. Murphy, you might need to go back to page 1282. There we are, the centre of that page. We'd been talking about the colours, the jury may recall. I know it seems a while ago, but we were talking about the specific rash from Leon Tanswell, about the bright pink movement on it, the markings of that rash, and there was this exchange at the conclusion of the evidence. It was after I had finished asking you questions. This was brought to your attention by the prosecution. The reference at the centre of the page, can you see, upon my arrival, purple blotchiness, right, mid-abdomen. Did you see that? Yes. So I'm going to stop at that point because the remainder of the discussion doesn't really focus on the dates of the 12th and the 13th that become so important in this letter that Dr. Evans has just written. So I don't want to go through the remainder of the cross-examination because this subject isn't really touched upon again. The remainder of the cross-examination is extraordinary, as whenever anyone asks Dr. Evans questions, it's always extraordinary. But there's just a couple of instances here. We see Ben Myers here asking about something that occurs on the 12th of June. Obviously, Dr. Evans could say, well, actually, I just realised the prosecution got the dates mixed up. That's the only reason the 12th of June is in the court case, as he's claimed in this letter. Again, there's another question here about it, and he just waves it off. There's another question here, and he just waves it off. And there's another question here, and I'll just read this bit. Could I just repeat the question? I just asked you that you have regarded the air that we see on that X-ray on the 12th of June as what is indicative of air having been deliberately forced down the nasogastric tube that day. And you have, haven't you? That was an opinion I've expressed, yes. Yes, that's right. You expressed it in your report, yes. I'm not going to read it out. On the 26th of March, 2019, didn't you? Yes. Yes, 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 yes. Couldn't be clearer. Not, oh, actually, the 12th of June was never significant. I'm just changing it. I'm just pointing out that the prosecution's got the date wrong, so I'm now bringing this up in court now. Given ample opportunities to say that, never said that. Also, it's very clear that he didn't cite this incident in his first report of 2017. In fact, he never cited it until he was in court, as far as we can see. I just wanted to mention this as well. So he did his usual thing of saying, well, I will answer the question. When I reviewed these papers originally, this was in November 2017, there was no suspect name known to me. So Judge Goss actually had to tell him to shut up and stop saying this over and over again, even though he hadn't been asked about it. And then since the court case, he's been asked about it he's brought it up numerous times in numerous interviews without being asked about it. Then he's brought it up in documentaries since the court case without being asked about it. I will leave people to reflect on why he keeps bringing this up over and over again as he's standing there in court, looking at the defendant Lucy Letby and changing his opinion in court. So finally, before I go into the conclusion, I just want to mention that I haven't gone over prosecuting barrister Nick Johnson and his interaction with Dr. Evans on the 1st of November 2022 when they're discussing Child C. Now, I have read all the way through this and they don't reference anything that is in Dr. Evans' letter whatsoever. I don't want to go over all of that. I can just say that the whole transcript is available here on Jabe's site, which is lucyletbyinnocence.com. It's very clear that he doesn't say anything that is even remotely resembling what he's written in this letter. And of course, that would be the time to do it because the prosecution would then have to hold their hands up and say, right, Your Honour, we've got one of the dates wrong for this case. The likely scenario is they would remove this case from the court case completely, as far as I can see. I mean, if someone has legal qualifications, they could offer their opinion on that. But at the very least, they'd have to tell the court, look, we got the date completely wrong, we got it mixed up, and now Dr. Evans is going to give you the correct date. Of course, nothing even remotely close to that happens. They don't even talk about the dates. In the aftermath, so if we return to what he says in this paragraph here, he says, in my very first report, I raised concerns regarding the event late on Saturday the 13th of June 2015 that led to his collapse and death. Over the next 5 years, the dates seem to have become confused, leading to the prosecution alleging that the assault took place the previous day. I recognised the confusion at the trial, reaffirming my original concern that the fatal assault was late on the 13th of June. I believe that Cheshire Police, the Crown Prosecution Service and the prosecution team should set the record straight. So there are two claims here. Dr. Evans changed the date in court because the prosecution, Crown Prosecution Service and or police made mistakes in court that he recognised. He never mentioned this at all. If we look at the court proceedings, there is nothing that is even remotely consistent with that. The second thing is that he claims he had included the 13th of June incident in his initial report. Again, the court proceedings seem to strongly indicate that this is not the case. Now, he could possibly, with regard to this, claim that he had cited the collapse, but that he hadn't specifically cited the mechanism of the splinting the diaphragm, which we know is complete crap that he's backed away from since. So it's possible that he could try and weasel his way out of the second one. He can't possibly say that he changed the date because the prosecution had made mistakes in court that he recognised. So he says very specifically the date seems to have become confused. It wasn't confused because he very specifically cited the 12th of June numerous times and conceded this in court. And indeed, he went into court intending to cite the 12th of June as being significant and as being the important collapse on which Baby C would be predicated as an allegation. He had countless opportunities, ample opportunity. He was specifically asked numerous times. He was also interviewed by the prosecution. Nothing like this was ever mentioned. It would be extraordinary if you recognised that the prosecution had got the dates mixed up, but then don't mention this whatsoever. We're not talking about one or two questions. We're talking about over 60 pages of him speaking in court, being cross-examined for 2/3 of that, being examined by Nick Johnson for 1/3 of that. He doesn't make any comment regarding the dates being confused. Finally, we're just going to look at this AI platform. Other AI platforms are available, but I find this is the easiest one to access for free. So this is completely unnecessary because it's absolutely crystal clear, but I just want to go over this as well, just so that we've absolutely established this. So I've simply asked this platform to say, please read the following statements. In my very first report, 7th of November 2017, I raised concerns regarding the event late on Saturday the 13th of June 2015 that led to the infant's collapse and death. Over the next 5 years, the dates seem to have become confused, leading to the prosecution alleging that the assaults took place the previous day. I recognise the confusion at the trial, reaffirming my original concern that the fatal assault was late on the 13th of June. I believe that Cheshire Police, the Crown Prosecution Service and the prosecution team should set the record straight. So then I've said, this statement relates to these court proceedings in which the person making the statement is given the answers denoted by A. This is occurring while being cross-examined in court. Are court proceedings consistent with the claims that he made in the original statement above? And then I've copied and pasted everything that you've just heard. We all know what the answer is, but I'm going to go through this anyway. Short answer, no. The courtroom transcript is not consistent with the claim that Dr. Evans had always or repeatedly maintained in his earlier reports that the fatal assault occurred late on the 13th of June 2015. The cross-examination shows his earlier position was agnostic or pointed to other possibilities, infection, possible deliberate error on the 12th of June, and that the specific mechanism of diaphragm splinting on the 13th of June was first advanced in his oral evidence at trial. Why? Brief point by point. November 7, 2017 report. He explicitly said one may never know the cause and that the baby was at risk of unexpected collapse, i.e. an open agnostic position. He accepted in cross-examination that his 2017 report did not identify splinting the diaphragm on the 13th of June. 2018 and March 2019 reports. He repeated that the cause might never be identified and that infection could not be excluded. In March 2019, he said it was probable infection was a significant factor in the late hours of 13th of June, again not a definitive allegation of a deliberate assault on that date. 12th of June concerns. By March 2019, he was explicitly suspicious about the 12th of June abdominal x-ray and wrote that excess air via the nasogastric tube on the 12th was a real possibility. Joint report August 2022. He signed a joint expert report concluding the massive gastric dilation on 12th of June was most likely due to deliberate exogenous administration of air via the nasogastric tube. The report does not advance splinting the diaphragm on the 13th of June. At trial cross-examination, he conceded that the first time he suggested splinting the diaphragm on the 13th of June as the cause of collapse was his oral evidence today. He also acknowledged that he had not previously identified a specific manner in which the baby was put in harm's way on the 13th of June in his reports. Conclusion, the transcript shows a shift over time. Initial reports were cautious agnostic and raised infection as a factor. Later reports raised suspicion about the 12th of June, and in August 2022, the joint report pointed to deliberate error on the 12th, and the specific theory that diaphragm splinting on the 13th of June caused the death was introduced orally at trial. That pattern contradicts the claim that he consistently raised and reaffirmed in his written reports over the years, a clear original position that the fatal assault was late on the 13th of June. So then ChatGPT rather hilariously says, if you'd like, I can draft a short, tightly worded summary or letter that extracts the key transcript passages and lines to send to Cheshire Police CPS to ask for them to set the record straight clarification you mentioned. Well, it's very kind of you, but I don't think I'll be pursuing that. So then I said, Did the person who wrote the statement give any indication in court that the prosecution had explicitly mixed up the dates and that the reason he was changing them now in court was to correct this mistake? Short answer, no. In the transcript, Dr. Evans does not say the prosecution had explicitly mixed up the dates or that he was changing his position in court to correct a prosecution error. Why? Key points from the transcript. When asked whether he had ever suggested splinting the diaphragm on the 13th of June before the day's oral evidence, Dr. Evans repeatedly agreed he had not. E.g., before today, you've never suggested that splinting the diaphragm on the 13th of June is the cause. That's correct. Later, the first time we're hearing it right now, isn't it? Yes. He explained the change as the usual clinical process, receiving additional information, pathology, other experts that can modify an opinion, not as correcting a prosecution mistake. His prior reports and the joint expert report focused on the 12th of June, suspicion of excess air via the nasogastric tube on the 12th and or on infection. He acknowledged the joint report concluded the 12th of June x-ray was most likely deliberate air. He did not say earlier reports had been wrongly dated by the prosecution. When explicitly asked whether he had identified any specific harm on the 13th of June in his earlier reports, he answered no and accepted that the splinting on the 13th theory was introduced in his oral evidence. If you wish, I can extract verbatim lines from the transcript and format a short note showing the passages that demonstrate this to use when asking the CPS prosecution to clarify whether they mix the dates. Which would you prefer? So ChatGPT is not too up to date on the way that politics works in the real world, but he did offer to extract verbatim lines from the transcript. So then I said, yes, please extract as many relevant lines verbatim as possible. Below are verbatim extracts from the transcript you supplied that are relevant to whether the witness said the prosecution had mixed up dates or that he was changing his evidence to correct such a prosecution mistake. I've labelled each quote with the speaker. Question equals questioner, Mr. Myers. Answer equals Dr. Evans. Before today, just now, you've never suggested that splinting the diaphragm on the 13th of June is the cause of death for baby C, have you? That's correct. This is the first time we're hearing it right now, isn't it? Yes. You have not in these reports, up until your evidence now, identified any specific way in which he was put in harm's way on the 13th of June, have you? Not in this first report, no. Reading para 33 from the 7th of November 2017 report, one may never know the cause of baby C's collapse. He was at great risk of unexpected collapse. All of this is correct. So you agree he in fact was at great risk of unexpected collapse. He was at risk of one or more of the complications you get in preterm babies we discussed earlier. You also form the view that you cannot exclude the role of infection in his collapse, paragraph 34. Yes, I am quite happy to elaborate on that. Quoting March 2019 report, it is therefore probable that infection was a significant factor in baby C's collapse during the late hours of June 13th of June 2015. Yes, I've seen that, yes. Quoting paragraph about the 12th of June, I am suspicious of the gaseous distension reported on the abdominal x-ray on the 12th of June. I wonder whether this represents inappropriate management whereby his attendant inserted excess air into his stomach via his nasogastric tube, doing so in the knowledge that it would cause the infant discomfort and distress. That was a possibility that crossed my mind at the time. About the joint August 2022 report, the massive gastric dilation seen on the X-ray of 12th of June was most likely due to deliberate exogenous administration of air via the NGT. That was our conclusion at the time. I think this was a just joint report, I think. In that report, a matter of months or a month or two before this trial commenced, you make no suggestion that the diaphragm had been splintered by excessive air on the 13th of June, do you? Right. That follows actually. Perhaps it wasn't said specifically. Can we establish that first of all? Yes, that is correct. You didn't. That is correct. If you really thought the splint in the diaphragm in the case of baby C was a cause of collapse, you would have said that before today, Dr. Evans. Not necessarily. I think when I came to this court, first of all, I said that having prepared these reports initially over 5 years ago, in virtually all of the cases I benefit from additional information since then, you know, from other experienced medical people, and if you receive additional information from other people in other disciplines, which allows you as a clinician to change or modify your opinion, that is what doctors do. Can I ask you this, Dr. Evans? Are you trying to use what you anticipate will be the evidence of Dr. Marnarides, the pathologist, to find a way of producing an allegation as to the harm that was done on the 13th? No, which you haven't made before today. Sorry, this baby was put in harm's way. What you have done in your evidence today is introduce something new with the purpose of supporting the allegation rather than explain the facts, isn't it? No, that is incorrect. I'm here to support the jury and everyone in this court trying to explain what it was that led to a baby who was very small and premature suddenly collapsing and where resuscitation was unsuccessful. Plain point from these verbatim extracts. The witness repeatedly admits the splinting on the 13th of June theory was not in his early reports and that early reports raised infection and or suspicion about the 12th of June. He explains any change as due to receiving additional clinical pathology information and not because the prosecution had mixed up the dates. There is no verbatim statement in the transcript where he says the prosecution explicitly confused the dates or that he is changing his evidence to correct a prosecution error. And then again, ChatGPT is desperate for me to write to the police. So finally, I have asked the platform, we know the answer to this already, but I've asked the platform, is there anything in the court transcripts that is even remotely consistent with the suggestion that Dr. Evans realised that either the police, CPS, prosecution or a combination of the three confused the dates and Dr. Evans therefore decided to correct them in court? Short answer, no. There is nothing in the transcript you supplied that even remotely supports the idea that Dr. Evans said the police, CPS, prosecution had confused the dates and that he was correcting their mistake in court. Evidence from the transcript, most probative verbatim lines. On whether he had ever previously suggested the 13th of June splinting theory, before today, just now, you've never suggested that splinting the diaphragm on the 13th of June is the cause of death for baby C, have you? That's correct. Number 2. On why his opinion changed, he attributes it to receiving more clinical pathology information, not to correcting a prosecution error. Having prepared these reports initially over 5 years ago, in virtually all of the cases I've benefited from additional information since then, from other experienced medical people, and if you receive additional information from other people in other disciplines, which allows you as a clinician to change or modify your opinion, this is what doctors do. 3. On the timing of the splinting theory, he acknowledges the splinting on the 13th of June idea was first advanced in his oral evidence that day. This is the first time we're hearing it right now, isn't it? Yes. 4. On the earlier focus being the 12th of the June X-ray and joint report, he confirms the joint expert view pointed to the 12th of June deliberate air via nasogastric tube and that the August 2022 joint report did not raise splinting on the 13th of June. The massive gastric dilation seen on the X-ray, the 12th of June, was most likely due to deliberate exogenous administration of air via the nasogastric tube. That was our conclusion at the time. In that report, you make no suggestion that the diaphragm had been splintered by excessive air on the 13th of June, do you? No. Why this matters? Dr. Evans consistently frames any changes as clinical based on new information, pathology, other experts, not as correcting a prosecutorial dating error. He admits the splinting on the 30th of June theory was new to his oral evidence and that his early reports were either A. agnostic, B. pointed to the infection, or C. raised suspicion about the 12th of June, not that early reports had the date wrong because the prosecution had mixed dates up. And again, ChatGPT wants me to write to the Crown Prosecution Service. So that is all the analysis of this that I can possibly do. I now just want to present my conclusion. Before we go over the conclusion, it's important for me to emphasise as well that the prosecution is bound by certain court regulations to disclose that a major mistake had been made with dates, particularly regarding what is considered a key incident in a court case for which a potential life sentence, and indeed a life sentence, was ultimately the result of the proceedings. This would then have to be shared with the defence and the court, as would the reasons for it. It's just basic disclosure. This requirement is outlined in the Criminal Procedure and Investigations Act 1996, particularly in Section 3, Initial Duty, that we have on the screen now. So I am far from an expert in this. In fact, nothing could be further from the truth. But Provision 3, Bracket 1, the prosecutor must disclose to accused any prosecution material which has not previously been disclosed to the accused and which might reasonably be considered capable of undermining the case of the prosecution against the accused, or give the accused a written statement that there is no material of a description mentioned in paragraph A. And then it goes on, that just defines what material is. Where material consists of information which has not been recorded, the prosecutor discloses it for the purposes of this section by securing that it is recorded in such a form as he thinks fit and by securing that copy is made of it and the copy is given to the accused, and so on. I'm not going to read the whole list out, it's usual legalese stuff. Then there's also section 7A, continuing duty of the prosecutor to keep disclosure under review. This section applies at all times after the prosecutor has complied with section 3. The prosecutor must keep under review the question whether at any given time, and in particular following the giving of a defence statement, there is prosecution material which might reasonably be considered capable of undermining the case for the prosecution against the accused or of assisting the case for the accused and has not been disclosed to the accused, and so on, and so it goes on. And then there's also the Criminal Procedures Rules 2020, Part 15 Disclosure, which deals with various aspects of disclosure in court cases. Not going to read all of that out. These are just statutory provisions which are supplemented by the Attorney General's Guidelines on Disclosure and the Crown Prosecution Service Disclosure Manual Judicial Protocol, which explain how amendments such as a changed date must be handled in practice. So the idea you can just have, even if there was any evidence that this is what Dr. Evans had done, which there isn't, if you just suddenly change the date, then and you asserted that this was because the prosecution had mixed the date up, as Dr. Evans does in his letter, you can't just randomly start changing things around in the witness box. There's very clear policies and procedures that would need to be followed. And I've only scratched the surface of those policies and procedures here. I don't really want to go into them in great depth because, firstly, I'm not particularly knowledgeable about them, and secondly, I'm sure you can all imagine that there's policies and procedures. Otherwise, anyone could just start saying anything in court and you could start shifting the prosecution case around. Disclosure and making the case clear before it's presented in court is sacrosanct. So that's another aspect of this that it's important for me to emphasise. And then finally, another new letter has emerged, which Dr. Evans wrote to Private Eye. There are some claims regarding the police in this letter as well, but I want to begin with this paragraph related to medical claims. Firstly, an injection of air into the stomach would compromise the breathing of a tiny baby, quickly destabilising him. An injection of air directly into the bloodstream would be even more catastrophic. Whilst one cannot exclude the former, the latter explanation is a more likely explanation for his collapse. One cannot rule out the possibility of his suffering from a combination of both. Either is indicative of inflicted injury, where the perpetrator would know that their action would place a vulnerable baby in harm's way. This evidence led to the jury finding Lucy Letby guilty of the baby's murder. Now, that might be superficially convincing for someone who doesn't know much about the case, or indeed someone who's a bit thick. But there is just the minor inconvenience that this isn't the diagnosis that Dr. Evans gave in court and is in no way consistent with what he said in court. Of course, in court, Dr. Evans stated that the actions of Lucy Letby splintered the diaphragm of child C, and he also said this in relation to other infants. He didn't say anything about compromising the infants, and the comments about the bloodstream are irrelevant because that isn't what he said in court. Now let's move on to the paragraphs related to the police in this letter. The clinical facts are straightforward. Baby C was a tiny baby who was responding satisfactorily to treatment for pneumonia until his unexpected collapse. My preliminary report dated the 7th of November 2017 noted that I have concerns regarding the unexpected collapse of baby C at around 1100 hours on the 13th of June 2015. I added that I would advise scrutinising the staffing present at the time. Lucy Letby's name as a suspect was not known to me at the time. See how it's always necessary for him to refer to that. As I've said in other videos, of course he wrote many reports when he did know Lucy Letby's name, and of course he changed his opinion on this when he'd already been in the same room as Lucy Letby in court. And there was no record of her presence in the infant's clinical notes. Cheshire Police's attention to detail confirmed that the infant's collapse occurred when in Lucy Letby's presence after the baby's designated nurse had gone for a break. Lucy Letby's involvement was noted in more detail in evidence given at the Thirlwell inquiry on the 9th of October 2024. So let's compare these two paragraphs. Cheshire Police's attention to detail confirmed that the infant's collapse occurred when in Lucy Letby's presence after the baby's designated nurse had gone for a break. Over the next 5 years, the dates seem to have become confused, leading to the prosecution alleging that the assault took place the previous day. I recognised the confusion at the trial, reaffirming my original concern that the fatal assault was late on the 13th of June. I believe that Cheshire Police, the CPS and the prosecution team should set the record straight. So remember, these paragraphs are written just weeks apart. In one of them, Evans praises Cheshire Police's attention to detail, and in the other letter, he claims that they got the dates mixed up. Let's go through the timeline now of everything that Dr. Evans has said in relation to Child C and in relation to him changing his mind. So, first of all, he denied that he'd ever changed his mind. This is in the BBC. He later reaffirmed these claims, speaking with The Guardian. Dr. Evans then submitted or conceded that he'd submitted a new report which clarified the situation. Except that he's supposed to have clarified this in court. It's supposed to be a mix-up over the dates, according to this new letter, and he's supposed to have corrected this in court. Except that we know for a fact that he never did any such thing because he's in the witness box for 4 hours and he never makes any reference to anything remotely related to this. He also repeatedly cited the 12th of June as being the key collapse, even going into the court case and also in multiple reports. And then he changed that at the last minute during the court case because Lucy Letby wasn't on duty. I'll just mention briefly, after this new report was submitted, the CPS refused to hand it over. So to rewind back to the publication of the Guardian article, days after this, the Guardian revealed that Dr. Evans had conceded that he'd changed his mind during email correspondence. Then Dr. Evans appeared in BBC Panorama, conceding that he'd changed his mind, but claiming that it didn't matter which diagnosis or day that he'd used. He then gave what can be described as a remarkable performance during the recently broadcast Channel 4 documentary. And now he has written 2 letters within weeks of one another, possibly days of one another, which completely contradict one another and, needless to say, contradict numerous other things that he said previously. Oh, and let me just briefly mention that he wrote to Channel 5 contradicting himself again, and that he's praised the Court of Appeal several times, even though we know that the Court of Appeal verdict contradicts his own public statements. In fact, we know that the Court of Appeal repeats the theory that he has now jettisoned in relation to other infants in the case, which is a perfectly natural thing for the Court of Appeal to do because that's what he said in court. In conclusion, there are 3 simple points to make. Firstly, the claims made in the letter that I highlighted throughout this video are simply untrue. Secondly, it is ironic that this new private eye letter has been published in an attempt to defend Dr. Evans, as it simply reveals new information that makes him look worse than he did already, and he has contradicted himself once again. Thirdly, Dr. Evans is practically the definition of an unreliable witness.